The second misconception I see clients make about trial is that any evidence could be admissible in a hearing or a trial. Hey, my name's Courtney Driscoll. I'm a trial attorney, family law, and criminal defense attorney here in Oklahoma, and I own my own law firm, Driscoll Law Firm. Not all evidence is going to be admissible. There is something called the rules of evidence. That's what we as attorneys have to abide by when we are trying to enter certain pieces of evidence into the record during a hearing or a trial. That happens during the hearing or the trial unless you can get opposing counsel to stipulate to it prior to the hearing or trial. What I see happen sometimes, especially with pro se parties, is they will be coming up on a hearing or a trial and they want the judge to see a particular piece of evidence, so they just go file it with the court. But that's not how you get evidence admitted to the record. You have to admit it, like I said, most typically in the hearing or at the trial. And the reason for that is opposing counsel has the option to object to your evidence being entered. So for example, one of the things that you have to do with a witness if you're in a hearing or a trial is that you have to, if you want to enter a particular piece of evidence, you have to go through a list of questions to ask them to authenticate the evidence and lay a foundation. If you don't know how to do that, if you don't know what the right questions are, then opposing counsel is going to object and say, Your Honor, lack of foundation or a similar objection, and unless you're ready with a response, then the judge may say sustained, and then your evidence doesn't get to come in. So it's imperative that you know what the rules of evidence are in your jurisdiction and how to use them at the hearing or trial.